Okay, so it's Mark Fielding Pritchard here. Again, I appear to be sitting in the dark because it's so bright outside. The camera picks me up very dark, so let's spin it around a little bit. I don't get over the sunlight there. It just seems to make it worse, doesn't it? There we go. Better. You can see me now. Maybe that's better. Right, Mark Fielding Pritchard here. We've been running a few courses now on fraud prevention, anti-corruption, and one of the things that people have been very interested in is the debarment process. So I wrote a little lecture, a little PowerPoint presentation on the debarment process, but it actually turned out that it was going to be like 3 hours long. So what I've done is I've cut this down to just the US. So we've just got the American perspective here. So this is the debarment process in the United States of America. Please can you notice definite advice. If you're an American person and you're watching this and you're thinking, Jesus, this is something that might affect us, then I strongly recommend that you use this as a starting point. But this is not, there's not enough detail in this to be proper legal advice. So you must go and get yourself a lawyer or a procurement debarment specialist, or you can ask us, we'll come and help you. So this is the debarment process, but we're particularly looking at this from an international perspective because the training that we do is for governments, procurement departments in governments all around the world. The United States American government doesn't need our expertise. So, Mark Fielding Pritchard on the debarment process. It's really a look for international people who can get an overview of the American process and then they can compare that to their own process or use this as a starting point for developing their own process. Okay, there we go. Now to make it stop. Okay, so there's two main areas that we're going to look at. The first one is the Federal Acquisition Regulations. So these are the regulations that cover procurement for the American government. And in particular, the debarment rules are in section 9, so I'm particularly looking at them on the screen now, 9.406. What these regulations do, in particular this section, is that they set up someone who's called the debarring official. Now, what you'll find with the whole of this American system, therefore, is that everything is completely discretionary. So we have this one guy, and he is judge, jury, and executioner, and he gets to basically completely make a decision. So if he doesn't like your face, you're kind of stuffed a little bit. Right, that's the background to it, and I'm sure that there's lawyers all over the United States of America now twitching wildly around me. But this is the background to it. Right, section 9.406, and you can Google this, it's free download from the American government, and it sets out what the guy can do. Right, it says that I'm just reading this now, the debarring official's responsibility is to determine whether debarment is in the government's interest. And it also goes on to say that the existence of a cause for debarment, however, does not necessarily require that the contractor will be debarred. The seriousness of the contractor's acts or omissions, any remedial measures should be taken into consideration. Right, what has to happen, therefore, is that there has to be some effective wrongdoing. So the supplier has to have done some wrongdoing. And we'll come back to what that wrongdoing means in a second. Right, assuming that there is some wrongdoing, the debarring official will then look at what happened next. Now, if you go to section 9.406, it will tell you that if the contractor has effective standards of conduct, if the contractor has brought this to the attention of the official, and notice that, therefore there is a requirement for self-disclosure, and that's what my PowerPoint slide is getting at, because that's a big thing in real life. So if the contractor comes forward and goes through really sorry about this, and then they take remedial action, then in principle, the debarment official is supposed to take notice of that. And it then goes on to say all the usual stuff, whether the contractor has fully cooperated with the government agencies, whether it's paid all of its liabilities, whether any remedial action has been taken, agreed remedial measures, including those identified by the government, and so it goes on. There's a list of 10 of them in the standard there in the regulations, but you should use your common sense. Basically, if you come forward and say, we've done this wrong, we've now put in a committee to review these things, plus we've taken some remedial action to ensure everything is done, then you would hope that if your debarring official is a normal individual, then you should be okay. But these are the kind of things that the debarring official, and this is this judge, jury, and executioner guy, will take all of these things to account. Hopefully he's going to be a reasonable person. So 9.406 there sets out these things. Right, as we go over then, the next section that comes then there is that what these kind of things are. So in other words, what things can you have done wrong? Right, the kind of things that you can have done wrong, therefore, are the obvious stuff. Section A up there is performing public contracts. after a fraud. So therefore you're in the commission of a fraud in connection with obtaining, attempting to obtain, or in the execution of a government contract. And then there's embezzlement, antitrust. There's one that comes up all the time, which I suppose is my favourite. And this is to be an enormous crime according to these documents. And this is affixing a Made in America inscription, presumably when the thing isn't made in America. I guess if it's made in America, okay. Right, now there's one clause in here. So we are now into 9.406-2, and the clause that you have to be really, really careful of is number 5, because number 5 says commission of any other offence indicating a lack of business integrity or business honesty that seriously and directly affects the present responsibility of a government contractor or subcontractor. Right, just get your nips around that one for a second. That means that if there's anything that you do that this guy considers to be indicative of a lack of business integrity, then he can ban you or he can debar you. So you have to be really, really careful of that, because something that you consider to be normal business practice, he may not consider to be normal business practice. And his opinion is the one that counts. Right, all of the other stuff comes in there as well. Violation of terms of a government contract, willful failure to perform a contract, a history of failure, violations of a drug-free workplace. So I would imagine that anyone would forgive you that. Sounds like a good place to work. A number of employees convicted of violations relating to drugs, more again are Made in America inscriptions, and so on and so forth. Right, therefore, if you're looking at this at home and you're sitting in a government in Africa or Southeast Asia, it's called the Federal Acquisition Regulations. It's subpart 904, and have a read of it. And it's actually remarkably readable. Part 1 is called, it's all debarment. Part 1 is general, and then part 2 is the causes for debarment. So on my slide, that's the first thing that we've got there. That's your government federal acquisition regulations. I'm British, so the concept of government and state goes straight past me. So these are federal, so this is the federal government, federal acquisition regulations. Right, the second thing that we have on our slide is false claims. So this comes under the US code number 3729, and there's 4 or 5 sections on this, but the main one is 3729, and 3729 looks at false claims. And again, false claims is simply a list of things that you can do which will get you debarred. So making claims for payment when you haven't done the work, having in possession control of property or money that belongs to the government, and so on. Knowingly buys or receives as a pledge of an obligation of debt public property from an employee who lawfully may not sell or pledge the property, and so on and so forth. And it goes on and on and on through the, I say on and on and on. It doesn't go on and on at all, actually. It's only like one page. There are A, B, C, D, E, F, G, down to G. And G knowingly makes, uses, or causes to be made a false record or statement of material to an obligation to pay or transmit money or property to the government. Right, so in other words, it's false claims. You're holding yourself out to be something which you're not, and that holding yourself out has a connection to the government. So therefore, you're not permitted to do that. Do those things, and you will find yourself debarred. Okay, so back to our slide. Therefore, we have these 2 places that we have to look: the Federal Acquisition Regulations, subsection 9, False Claims Act. Have a look therefore at 3729, and you'll see the false claims in there as well. The third thing that we put on the slide therefore is where it just says more aggressive use of suspension and debarment, is that if you go back to sort of 1990, basically nobody ever got debarred back in those days. Now it happens all the time. More and more people are having this done to them, and the government is becoming much more aggressive. There is much more of a culture of not only being honest, but showing that you're honest as well. Almost to some degree a kind of an element of, well, we have to ban a couple of people a year just to show the system works. So that's the background as well, and I put that on the slide because it's very important now, because this stuff is becoming more and more used. So slide number 3 therefore looks at what the objectives of this debarment process are, and I guess therefore that you can read the slides through as well as I can. It's intended to protect the government from future dealings with contractors or grantees that are unscrupulous, unreliable, or incompetent. I guess I've got three things to say about that. The first thing is that obviously one of these things is to protect the government from financial risk. So when we say financial risk, therefore the government is paying for a project to be carried out. When the project is carried out, it doesn't want to find that it's paying for something that it's not getting. So it's not getting value for money on its contract, or it's giving money to contractors as upfront payments and they're stealing that money. So we get this idea of financial risk. So we're protecting the government from financial risk. The second thing is that we're also looking at reputation risk. The government, irrespective of which side of the political spectrum you're on, has to be very much aware that voters and taxpayers are watching them, and the government has to be and be seen to be fiscally prudent and have some reasonable level of quality in its dealings. And so therefore we have this idea of reputation risk as well. So we've got financial risk and we've got reputation risk as well. So we're looking to protect the government on those two elements, financially and reputationally, if that's a real word. The third thing I do want to highlight to you that we've picked up there is look at the word though, which is there in future. Now, this is one of the stated objectives that they have, and this has raised issues because let's assume you have an organization and it has 3 contracts and it under-delivers on one contract, so it's debarred on one contract. Now, how does that affect it in terms of timing? Does that mean it's not allowed to rectify that contract? Presumably it ought to be. But secondly, what about the other 2 contracts where presumably it isn't underperforming? So we get this idea therefore, and this is actually where this is drawn from. I think that where I got the sources of information was saying that with some of these things, what we're seeing now is that this isn't being strictly applied. Once a company has problems on one contract, it can spread to other contracts as well. A situation which can presumably lead to the bankruptcy of an organization if it's not careful. Right, so we've got debarment processes, financial risk, reputation risk, but we've also got this idea here of when, and we've got this concept of being into the future. And I think that the articles that I've been reading as background to this are showing that in fact this is not commonly applied across the system. So slide number 4 therefore is to give you an overview of the process. At the centre of the slide in the green circle we have the suspension official. He's moved from being a debarment official to a suspension official. And if you remember, this is the guy who pretty much has carte blanche authority to do exactly what he wants, when he wants and how he wants. So as a point of principle, what is the guy supposed to take notice of? Right, well, the guy is supposed to take notice of various factors. So I've listed those on the left there. We'll start at the bottom, do them in reverse order to make them more exciting. Right, one of them is previous performance. So if you have an organization which has performed certain contracts for you before, you would expect to look at their previous performance. And what have they done on those contracts? So have they performed well? Has there been any issues of fraud, any issues of overbilling, any issues of expenses, and so on and so forth? If the answer is no, and what we're looking at now is a one-off situation, because presumably, I want you to, in terms of the slide, is to say, okay, we have a potential issue here. So if everything's been fine before, then that would be quite persuasive. The overarch as well is that when we're looking at this, we look at this situation as to how it affects the government. So you don't only have to look at previous performance on government contracts. You may want to take into account on non-government contracts as well. Though that hasn't, we'll see a case study later, and in the case study we'll see what the company did. But we've got this idea of previous performance. So previous performance, how does that impact on it? Number 2 is the contracting officers. So the procurement staff, bearing in mind that the suspension official ought to be separate from the contracting officials, the contracting officers therefore will be giving you their advice. Is this a good company? Is this a bad company? What are your dealings like? And if these guys are out there in the market every day and they're buying fairly specialised stuff, they should get a feeling of what this company is. So what kind of information are they giving back to you? Number 3 is fraud investigations. So what kind of information are we getting from fraud investigations? Are there any undergoing? Bearing in mind that we shouldn't really be taking into account any investigations that haven't been concluded unless they've shown up some unalienable facts that put our company into the not trustworthy group or bank there. So what's happened to these fraud investigations? What's happened to those as the company come out of them? and bearing in mind, of course, therefore, that what remedial action have they taken? Have they hold their hands up and gone, yeah, we're guilty, we're going to do everything, or have they gone, no, are they appealing, and so on and so forth. So we get this group of these group of things as well. I've included in the slide as well competitors, because competitors there, what will happen with competitors is you may find that they obviously want to submit information to get you debarred. You have to bear in mind where that information comes from. Also, the competitors is, do we have someone else who can slot easily into their place? What are the terms of contracts that competitors offer? Are the competitors in similar issues? Because in fact we're misinterpreting an industry norm. And so you can look at the competitors certainly for kind of background knowledge. Other things, if other people have contracted with this company, if they don't mind giving information to debarring official, you can find out how the company's worked on other contracts as well. So we get this idea that we get certain headings, and then within those headings that we will build up a body of information. Based on that body of information, the debarment official, the suspension official will take a view, and then they will suspend or debar, as the slide says. Please do bear in mind that this is a totally discretionary process. So therefore the suspension official will make his judgment, and once he's made his judgment, that is his judgment, and it is made. So let's just spend a little bit of time now then revising what we've already said. I took this from an organisation on the internet that I found called Montac, and I thought this was really quite useful because it's trying to get it to be as interesting as possible here. So suspension and debarment are measures intended to protect the government and are discretionary. So there's just a reaffirmation of this idea that it's totally discretionary. And the next sentence tells you that even if there is a reason why you might want to debar a company, you don't have to. So the kind of whole thing is sort of up to you really. And we'll look at mitigating factors and why not. It says neither the FAR and the FAR are the Federal Acquisition Regulations, nor the CFR, which is the Code of Federal Regulations, two particularly thrilling documents there. They both neither of them rather define what present responsibility is, but this idea that the organisation is responsible for some factor. And then it talks about remedial measures, so that if they come with their hands up, they make public disclosure, and then they offer to put things right, that should all be mitigating factors for you. So there's nothing new there. I think I just put that in there because it's a nice little paragraph that I think sums up what we've discussed already, and it's something that you can cut and paste there, and you can stick into any little reports that you're preparing yourself. So slide number 6 then, and we kind of touched on all of this stuff again. We talked about before we do that, let's see what this is. It tells you at the top of the slide. So FAR is your Federal Acquisition Regulations, and it's subpart number 9407-2, romantic in the extreme. And it just gives you a list of why you would want to be suspended there. So we've got frauds or crimes in relation to public contracts, antitrust violations, embezzlement, bribery, false statements, tax offences, drug-free workplace violations, an interesting one there, and false made in America inscriptions, my personal favourite. Unfair trade practices, delinquent taxes, failure to disclose credible evidence of violations or overpayments. That's another one there as well, overpayments. Now what you describe as an overpayment is very much open to interpretation. Or any other offence affecting present responsibility. Right now just get your paws around that last one there. That is a massive all catch that the Americans have inserted there. Remember, if you're watching this and you're thinking, what am I going to do in my country, and you've got a report to write, bear in mind, because this is totally therefore at the discretion of the individual. Okay. And slide number 7 continues in the same vein. So conviction of civil judgments. So notice that these are civil, not criminal now. So frauds, antitrust violations relating to submissions of offers and tenders, embezzlement, bribery, false statement, tax offences in civil courts again. False made in America inscriptions, so notice inscriptions as well, and any other offence affecting public responsibility. Finally, preponderance of evidence, so serious violations of government terms, drug-free workplace, your good old made in America, unfair trade practices, delinquent unpaid taxes. I think with the taxes you have to wait until the assessment's final and that you've exhausted every possible course of recourse to avoid paying your taxes. And failure to disclose credible evidence of criminal violations or overpayments. again, it's more of the same stuff. It's everything. That's your problem with this. It is absolutely damn everything. So if you fall foul of this, what happens to you? Well, it says a temporary and indefinite exclusion from contracting. Right, notice that temporary and indefinite. You've been banned forever. So basically the guy can just ban you forever. Pretty cool, huh? But it does say here that there's an immediate action required to protect the government's interest, so it can be done immediately. And in general, it will not exclude 1 year, at which point you can ask to go back into the list of approved contractors. And here we have this during the pendency of an investigation or proceeding. So you can actually be banned also while there's an ongoing investigation. And then if you're found not guilty, you come back onto the list as well. So notice that, therefore, if they have serious doubt, they can ban you just because there's an investigation. So you're guilty until proven innocent. If there's adequate evidence of non-responsibility, then to look at this adequate evidence, we apply the probable cause standard. So it's more than 50% likely. Indictment for any causes for suspicion constitutes adequate evidence. If you are indicted, that is already considered to be adequate evidence. Right, notice that. Someone somewhere accuses you of something, that is adequate evidence. And it says here judicial or fact-based. So what has actually happened? Right, so therefore, if you've been convicted of something, of a crime on one contract, you're pretty much guilty across the board. So if Department of Defense finds you guilty, they take you to court and you lose, then all the other government departments are well within their rights to ban you immediately, and they can certainly do that. If it's not based on an indictment, so therefore if you're not found guilty of something, then you can appeal, and you have up to 30 days to appeal. Okay? But pretty much this is pretty strict. So basically on the basis of an indictment, you can be banned forever. Right, this is a fairly obvious slide. Right, the EPLS listing is the list of excluded companies and organisations. So once you're on the blacklist, what happens is you go onto this thing called the EPLS. Once you're on the EPLS, then that's it really. I mean, as the slide says there for you, the agencies, so the individual agencies, commissions, ministries and bodies of the government are not allowed to ask for offers, they're not allowed to award contracts, and they're not allowed to consent to subcontracts as well. Right, notice that as well, subcontracts. So if an organisation wins a government contract, they cannot then subcontract work down to you if you're on the blacklist. Unless the agency can particularly show that there is a compelling reason, such as you are the only organisation that can provide this service. And it says there the commissioning officer who, having looked at the EPLS, looked at this blacklist, will reject bids from EPLS listed contractors and will not evaluate or hold discussions from companies which are listed on there, won't talk about quotes. You're basically locked out the conversation completely. It just sort of struck me after I turned the last slide off that I never told you what EPLS stands for. So EPLS stands for the Excluded Party Listing System. So your blacklist is called the Excluded Party Listing System. Right, what it's also telling us here then is what happens if you have other existing contracts and those contracts are in place. Well, you can continue with those contracts unless there's some particular reason why you don't want to. Now, if you've been in some sort of legal dispute with a supplier, then you may want to use this as an opportunity to get rid of them as well. But you may continue. But it says any termination action requires internal agency review. But it's just telling you, internal agency review. A couple of guys guess, yeah, lose these guys. Contract's over, and you can probably, depending on the terms of the contract, breach the contract on those grounds. Right, so we can continue or we can stop other contracts. If we continue with them, it says we must not place orders that exceed guaranteed minimums in these IDIC contracts. So IDIC contracts will have guaranteed minimums in them. Right, an IDIC contract is indefinite delivery, indefinite quantity. So we sign an agreement with a stationery company to provide paper, and then it means that our procurement department can just phone up and order paper, and the paper will be delivered whenever in the future, and the price will be fixed, will stay the same. That's an example of an IDIC contract. Right, those will have minimums in them. We're not allowed to go over the minimum, so we can only stick down to the minimum. We're not allowed under optional use contracts to have any more orders, so we're not allowed to extra paper or add in extra offices, and then we're not allowed to add new exercise options or otherwise extend duration of current contracts. So it kind of draws a line on it, so it's really, really serious. I think this is something I want to come back to. Lots of companies will end up making most of their money off of government contracts because they provide consulting in a certain area. I guess if that's the case, then this is telling you just don't risk it, because if you lose those contracts, basically your business is over and you're done, aren't you? I wanted to give you an example. So the example I chose was the Air Force. Everything's about Americanness. This is the US Air Force, and they debarred a company called FedBid. Now, FedBid was a really interesting company because what FedBid does is it runs what are called reverse auctions. So a reverse auction is just like a normal auction, except that everything works in reverse. So let's assume that I want to provide bus services. So bus services to a school. And I will run bus services, and I will go around and pick up all the kids in my town and take them to the local school. Now there are 3 other people who want to do this. Now what happens is, therefore, is that we open the auction and I say, okay, I want $1 million. And someone else will then bid and they say, okay, well, Mike wants $1 million, I'll offer 900,000. Someone else will go 800,000, blah, 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 blah. And then what happens is that, in fact, and that's why it's called a reverse auction, because the price goes down and down and down until we get to a minimum price, which is, let's say, 600,000 bucks. One guy hits 600,000 bucks, no one else wants it, and he wins the contract. So it's called a reverse auction. It's very important that it's very, very clearly defined in terms of what the services are, and then the bidders obviously get to see and hear everyone else's bid. And we have an auction. The difference is that the price goes down rather than going up. Right, there is a company called FedBid, which is very, very famous, and FedBid was set up. It was an idea that they took to various private investors. They got several $1 million and have become a very, very large company in this reverse auction business. It was discovered that this was just good old-fashioned fraud and corruption. What these guys were doing is that they were effectively paying bribes to certain individuals within procurement offices, and therefore that they would use the FedBid product to run what was supposed to be open auctions. As a process, the reverse auctions is very, very popular. It's very difficult to fiddle the bids because the whole thing is very, very transparent. It's all done within the internet, and you can have conference calls and live screens and blah, blah, blah. Right, and so basically what happened was this individual who is called Susan M. Taylor, and my apologies to Mrs. Taylor, I have no idea if the outcome came, but from the article that I read in the article, which actually came from the VA, so the Veterans Association in America, they have decided that this Mrs. Taylor was engaged in conduct prejudicial to the US government, and I believe that the background to this was that there was bribes and so on being offered. Right, go and read it. What happened was, therefore, it was a big discussion, because the big discussion, and there are numerous articles that basically said that the Air Force won't do this. Right, and won't do this means that they won't ban FedBid from this because they're too valuable to them, and because the other companies in the market are nowhere near as well established and probably as good at providing the product as FedBid were. The bottom line is that they did it. They actually went through it, and the Air Force has actually debarred this company. So the company now cannot bid for any more contracts from the Royal Air Force, from the American Air Force. If that is the situation, then I don't actually know the administration of this, but it's possible that FedBid will not be able to therefore also do anything else for the Army or the Navy or any other military organizations, and any other US government organization that wants to ban them now has valid evidence. Matter of fact, they've been caught. So have a read of that. It's fairly short. I mean, they're banging someone money, whatever, and that person then is making sure they win bids. But the irony of it is that it was for reverse auctions, which are a very valuable tool in fighting bribery and corruption. Okay, go have a read of that. You'll find it on the internet in 1,000,001 different places. Okay, so we've looked at the process of debarment, we looked at the federal acquisition regulations, we looked at the code of federal regulations, we looked at kind of things that people can do to get themselves debarred, and then we looked at the results of getting debarred. I gave you a little example, which is the which is the US Air Force. So my father served in the Royal Air Force in Britain for 26 years. I gave you the US Air Force versus FedBid, which is a nice little example of what can happen. The criticisms, it says here, I took this from this website, Mondac, which is very critical of this. So if you want to have a look in more depth at the criticisms, but the criticisms that they put is that there is that they want to see separation of adjudication and investigation. So in other words, the guys that prosecute a company are then the ones that decide if they're guilty, and they then are the ones and they then decide on what the punishment should be. So you know, if you could imagine being in court against someone who's trying to prosecute you, and you've got to persuade them that in fact not only are they wrong, but then that they shouldn't hit you too hard, and that's a bit of an unfair burden. So that there should be the equivalent of a jury who decided there should be a prosecution, a jury, and a judge kind of thing. It should be closer to a standard legal procedure. Right, centralized adjudications. This is because you just get vast differences. Some organisations, for even the slightest perceived infractions, will ban you, whereas others are just don't bother, you know. So we've seen great differences from agency to agency with the aggression with which they apply this, and also the weight that they put on various factors. The panel decision for companies or organisations, right? So this is the idea that if you get to a certain size, you shouldn't have just one person deciding, because if you piss that person off, or they have a particular point of view about one thing, then you're screwed. So you ought to have 3-4 people who are making 5 people, whatever, you're making a decision between them. So it's not just one person's opinion. Expanded right to an evidentiary hearing. So in other words, therefore, that there should be some right to have like a legal case where you can get to go and present your case, where you shouldn't just be debarred on the basis of a couple of emails. So there should be some actual proper process to appeal, and some proper process where you get to be heard to begin with. And finally, limiting the exclusion of affiliates. So if you have a company that has 5 subsidiaries, if one subsidiary is debarred, that doesn't mean that the other 4 should automatically be debarred. This was one of the claims that we had in FedBid. What happened in FedBid was that the case, I maybe should have mentioned this, is that FedBid had an executive, and that executive was accused of collusion with this lady Susan, I forgot her name, Susan Thompson. And what FedBid did was it actually went to an personal organisation, a corporate reorganisation, and it split its business into 2. So it split into military and it split into non-military. I think actually it split into government and non-government. The guy who was charged and accused of the corrupt activities was moved so that he went into the non-government section, and then the government section only had people with clean hands in it. And I think that was one of FedBid's defences, that they'd gone through this organisation as a mitigating factor, and the person that the government didn't like had been moved away from government contracts completely. Obviously, the Air Force didn't accept that as an acceptable mitigation factor, but that's what we're looking at here. This idea, therefore, that there should be limiting factors between departments, companies, and companies, and so on and so forth. So if you get one guy who does something wrong and the company fire him, shouldn't affect every single company in the group. Okay, there we go. Those are the main criticisms. It's something which is under constant review. Any process which is discretionary is always going to come under scrutiny and always come under criticism from organisations. In other countries, the European Union, for example, it's more prescribed. Okay, thank you very much for sticking with me, staying with me all the way through all of that. Just to recap, the work that we've been doing is training for governments around the world, not in the United States of America, on fraud prevention, anti-corruption. This debarment stuff has come up and people are very, very interested to know about debarment processes. Please notice I'm not a US-American lawyer, so therefore if you are watching this and you have an issue, you should go find yourself a proper qualified lawyer. But we'd be more than happy to come and do some training for you, of course. This is an example of one debarment system. There are numerous other systems, debarment systems around the world. My problem was that it literally became a 3-hour video that no one in their right mind is ever going to sit through, and that's why we concentrated on the United States of America. If you have any questions on this, or if you spot any mistakes as well, please send them in and we'll be happy to look at them. Thank you very much for your time. We have a whole stack of other videos on our website and other places, and best luck. Bye.